Hello, Scott Thomas here, Stewardship Matters. So glad you could join us for this webinar. I'm very, very excited about my guest today. I am Scott Thomas of Stewardship Matters, and I've gotten a lot of requests. I did a survey this last year in 2021, and one of the main things that people wanted to know about was estate planning and how to dig deeper into that, how to unpack it, and how can it benefit the other things besides just a will. So my very special guest today is somebody that I've known, I trust, I've worked with, Chad Shimel. Chad, tell us just a little bit about yourself, and then we'll jump right into this.
Hey, Scott. Thanks for letting me join you today. I appreciate the opportunity to come and talk with you. As you probably know, I've been a practicing attorney for about 15 years now. And a large portion of my practice has been devoted to estate planning. So while I do a few other things, including real estate, I do try and focus a lot on the estate planning aspect. So yeah, I've basically lived in Central Florida for about 15 years. I'm married. I've got 5 kids. And estate planning, I found to be an important part of my practice. And I think it's a good topic. I think it's something that everybody should learn a little bit about so that they can better plan for their futures.
Yeah. Well, excellent. So I get questions about, well, can I just write a will? Can I just handwrite it? Do I have to go see an attorney? What kind of happens? Does the state of Florida have a will for me? What does that look like? And why do people have to have a will, or why is it a good idea to have a will?
Yeah, no, that's a good question. It's a very common question. So the bottom line is, can you do it yourself? The answer is technically yes, you could do it yourself, but we don't recommend that because there are a lot of intricacies that come along with the estate planning process that, if they're not followed properly, can create big problems for people down the road. So while people can do it for themselves, we don't recommend that. We'd recommend you go see a lawyer and have it done properly. There are programs that you can use and utilize that different companies have come up with over the years. But again, just to make sure that it's done properly and that all of the I's are dotted, the T's are crossed, we do recommend, there's certain signing requirements, witness requirements, notary requirements, and to make sure that all of that happens in conjunction with actually developing a plan that works best for that person's family. It's very important that it just be done and handled right, and that you don't make any mistakes there. So, and if you don't, like you mentioned, does the state of Florida dictate something? Well, yeah. The state of Florida does. If you don't do anything, if you don't do your planning, then the state of Florida has statutes that deal with intestacy. And the statutes dictate what will happen when a person doesn't have a will and yet has assets that need to pass after their death. So the state dictates, okay, if you do nothing, then this is how your various assets will pass according to statute. So, but you can completely control that yourself. And we encourage people to do that in advance, so that you create your own plan, and that way what you want, your wishes, your desires are what actually transpire.
Yeah. So one of the conversations I've been having with clients is you've got an adult child, and this adult child is 18 or older. They may be off at college. I've done this for my boys when they were in college. I got them a will. I got them the whole package of a healthcare surrogate, durable power of attorney, the living will, all of that, because I've seen tragic stories. You and I have talked about this, and there are a lot of tragic stories where here you have someone who's 23 years old, and you feel like as a parent, hey, this child is my child. If something happens to them, they're in a car accident, I have the right to go in there and say what needs to be done and be their healthcare advocate. But what's the reality?
Yeah. The reality is that you don't always get to make those choices. Or if you do, you have to go through some process to be able to make those. So yeah, we encounter the situation regularly where people, a lot of people will feel like, I don't have much, in terms of assets. I'm relatively young. I'm 15, I'm 20, I'm just in college. Why would I need to do estate planning? And so a lot of the times it's not, the reason to do it is not because of financial reasons. The reasons to do it is often because of medical related reasons. So one of the primary things for younger individuals who are over 18 and have not yet established, financial reasons to do it is to basically, establish some medical directives, advanced directives for what those people want to have happen in the event of an unfortunate accident where they are incapacitated and they can't make decisions for themselves. So yeah, I would encourage anybody over the age of 18, regardless of your financial situation, to consider doing your basic estate planning documents. You don't need anything fancy. You don't need anything drawn out and lengthy or anything complicated, but you should ensure that the basic documents that protect you and your family are in place, because it makes the process a lot easier and smoother for your family if you've done that. So yeah, we do encounter those situations where tragically people could have done something even basic that would have really helped the family, but they just didn't do it. And oftentimes they just don't think to do it.
Yeah, so I'm thinking of some life transitions, some moments when you really need to update a will and your package and the things that you have. And one would be obviously getting married. One would be getting divorced. One would be I've started a business, or I have a business partner or partnership. In fact, I have a family story where one of our family members had gone into a partnership for some property years ago. This was 1990, and they had a stroke and became incapacitated. And getting a guardianship for him in that situation, it would have been $50,000 just for that guardianship, but the attorney was very gracious and was generous and only charged $25,000, and it took about 3 months to solve the problem. And that was in 1990. Mm-hmm. And that was a big wake-up call for our family, for my practice. So as I talk with people about these life transitions, really important to know that it can cost you a lot of money and time and heartache. And I would say that this family member that had to deal with this the most, it wasn't the money that was the worst part. It was the hassles, applying to the courts, the ongoing process that it took that could have been avoided.
Yeah, it's all too common. It really is. I'm sorry to hear that you had to go through that, but it's a very common situation. People don't ever think that they're going to need anything. But then when time comes, it's too late. At that point, there's nothing you can do about it. Once somebody is incapacitated, there's literally nothing you can do other than go through this guardianship process, which involves a probate court, a guardianship court, and you have to jump through a bunch of different hoops that cost a significant amount of money and take a significant amount of time, all of which are even more stressful and straining on the family because they're going through some life event that is already tragic. So it just really complicates the process. And that's why that advanced planning is so important. But that situation is very, very common. And it's a situation that can be avoided with some very simple, very basic planning where you designate individuals to make your healthcare decisions, or, you designate even who will be your guardian if one is necessary. And parents of young children, that's very important. Those are kinds of things that you can take care of in advance to pre-plan for those conditions. Because the last thing that any family wants to be dealing with is a court process that's expensive when they're also dealing with whatever the family tragedy is that they're walking through. So that becomes very frustrating for people because they just don't want to have to deal with that aspect of it. They just really want to be dealing with the issue at hand, which is the care of their loved one. So that's, it's sadly, it's all too common.
So let's back up for a second. You just mentioned, so you're a parent of a young child, minor, and guardianship to say, who will take care of my children? Okay. That's one aspect, which is who's entrusted to their care. And if you didn't have that name, and let's say you had 2 or 3 siblings and now they all wanted to fight over your kids. Have you seen that? I mean, I've seen it once.
I've seen it a lot in my
You've seen it a lot. Yeah.
I've done a fair amount of guardianship practice, guardianship administration, over the years. And so sadly, what you find is that oftentimes families don't get along, and what a guardianship case will often resemble is a bitter divorce family law situation where family members are literally fighting with each other over the care or the handling of a child, and what's best for that child. It's often with good intentions, but nonetheless, it becomes even more drama for the family to deal with because somebody didn't pre-plan for that. So in the situation where you have someone with minor children like myself, it's so important to designate who you want to take care of those minor children in the event that you are not able to do that. And, in a marital situation, it's typically the spouse that would take care of them. You don't need any paperwork for that. You're both legally entitled to do that. But if something happens to both of you, or if you're a single parent, then who's going to care for your children? And if it's, a temporary matter, caring for them while you're incapacitated, that's one thing. Or it could be a lifetime matter in the event that you pass away. Who is going to care for those children? Where we will often find the dispute is, sadly, between two sets of very loving, kind, and generous grandparents. That when someone passes away, grandparents want to take care of their grandchildren. That's natural. But, if you don't designate who, then you can end up with a situation where both sides of a family are arguing over who is best able to care for those children. And we also encounter situations, it's not uncommon, where a family does not want other family members to even be involved with the care of their children. They may love their family, but they, in no situation, do they want their parents to be raising their children for whatever reasons that might be. And so if you want to prevent that from happening, then it is imperative that you do the planning so that you can designate other friends or other family members that might not be first in line to serve in those roles to be the person to care for your kids. So again, going back to the idea that you don't have to have a lot of financial resources to prompt the estate planning process. If you have children, it is a tremendous reason to do your estate planning, even if it's simple, even if it's basic, so that you can designate who cares for your kids in the event that you can't. And I think practically every parent of a minor child can envision a scenario that, they don't want to find their family or their children in that situation. So pre-planning for that is one of the main reasons that we see a lot of younger individuals who, for financial reasons, have no real reason for doing it. But for personal family reasons, guardianship reasons, and minor children reasons, they want to take care of it.
A question that came up when my children were younger, and I would share with some people that, hey, here's what we're doing. One of the questions came up was, I want my brother or sister or brother-in-law, I want this couple to take care of my kids, but I don't necessarily want them to manage all the money. And so I've seen that actually pop up where this couple is terrible with money, but they're fabulous with children. This other couple over here, or this brother or sister, is fabulous with money, but I don't want them to be the guardian of my kids. And so sometimes I've seen some separation of who has financial oversights and who has the actual custodial side. Do you see that? Does that sometimes pop up in your practice?
Very common. Yeah. And that exact scenario happens a lot where you have people who are just simply better able to care for children, but may not have the financial minds to deal with the financial complexities that come with it. And you have other individuals who are great with the money side of things, but maybe they just don't have the time to deal with actually managing or caring for children. Maybe they're physically distant. Maybe they have other obligations in their life that would just prevent them from doing it. But we do see that a lot. We see people who say, this individual or family, this couple would be great to raise my kids, but I want the money to be managed on this side over here. And that's perfectly fine. You can absolutely designate that in your documents. And it's very common. It also, in a kind of weird kind of way, it is a checks and balance system. If you set it up that way, where you have two separate people who are involved, you don't have the guardian who's caring for the children also controlling all of the financial resources to care for that children, those children or child. So it's kind of a checks and balance system where you don't put all the power in one side of the equation. So where you can have two people involved that kind of make sure, one, that the care is being given to the child, and the other, that the financial resources are being used appropriately for the benefit of that child.
Yeah. So I want to shift a little bit more of the end of life. So my dad broke his hip a few years ago. And so we're at the hospital and we're saying, oh, we've got our advanced directives. We've got all this paperwork. We had this stuff. And they really didn't want to talk about it. I mean, they just wanted to know, okay, who is the designated healthcare surrogate person? And they wanted to see that. But they actually required our family to have a DNR that was signed on the hospital's paper. And so they put it into their computer system, but they required their own DNR knowing that he's going into surgery and he's 90 plus years of age. And we wanted to be clear about that. So that was something that popped up. What about the living will? That's kind of a strange thing because some people think it's a living trust or they get it confused. Give us a little insight on what does the living will document do?
Yeah, the living will, it does create a little bit of confusion based on name alone. It's kind of a combination of two different things. We've got what's often referred to as a living trust or a revocable trust. So it has the word living in it, but then we also have a will. And so when you combine the document has the name of a living will, people are like, wait, is this a trust or is this a will? What is it? Well, it's actually neither. And interesting, like you mentioned, it's also not a DNR. The DNR, the paperwork that you were mentioning, that's a document that a hospital will often present. It doesn't have to be in the context of a hospital, but it's typically where you'll find it. And that's an end-of-life document that says, do not resuscitate me. In the event that my heart were to stop, if my function of my body were to shut down, I do not want to be revived. And that, like you said, in a scenario where your elderly parent is going into a surgery might be an appropriate document to sign if that's their choice and they don't want to be resuscitated. On the flip side of that, that's not a document that someone who's 25 years old and otherwise healthy would want to sign. Typically, they would typically say, okay, yeah, if my heart stops then please do your best to revive me because I have, 40, 50, 60 years of life ahead of me. If I can just be resuscitated. So it's very specific in situation of who should be signing that type of document. But all of that to say, that's not a living will. The living will document is an end of life document that normally will say, this is my advance directive in terms of end of life. In the event that I find myself in a permanent vegetative state with very little or no medical chance of recovery and two physicians sign off saying, there's no chance that this person is going to have a quality of life. And all we're doing is keeping them alive with life support. They can choose not to live that way. And so that's what the living will typically dictate is that if that's your scenario, you just don't want to find yourself living in a vegetative state typically, then you'll sign a living will and that will authorize the person named to withdraw that life-sustaining support.
Yeah. So while someone is alive, but now they have an incapacitation. Let's say they either have a stroke, they're in a coma, car accident. Maybe it's a dementia slide, whatever that might be occurring. The durable power of attorney, limited power of attorney. Could you address why a power of attorney is important for someone who is either instantly kind of put into a position, maybe it's not long-term, maybe they're going to come out of it, or maybe they're sliding into a dementia scenario. Give us an example of how these power of attorney documents are helpful. And is this a normal part of a package that an estate planning attorney should be presenting? What should be in a will package, I guess I should say?
Yeah, that's a great question. So the answer to the question is yes, it's something that should be a part of every estate plan. It is one of the primary documents that in almost every scenario we would advise people to sign as a part of their estate planning package per se. And specifically the durable power of attorney, what we find with that document is that it's a financial related document. That is a document that is going to deal with a person's finances. But one of the things that we also want to point out to individuals that sign it is that it is a very, very powerful document, and it comes with an immediate effective date. So when you sign a durable power of attorney and you name someone in that document to have financial control or the ability to manage or handle your finances, you're doing that effective immediately. So I always like to point out to people that while it is imperative to have such a document, it's almost always advisable, it also comes with a lot of power. And so you want to make sure you're very careful about who you name, because the person that you name in that document literally has the ability to buy, sell, mortgage, and lend in your name the day you sign it. So you don't want to give that power and authority to someone that you don't trust completely with your finances. So, you don't want to give that to someone that you wouldn't otherwise trust to make banking decisions for you or pay bills or whatever, because that's what it can do. That's the power of that document. Is it lets the person named step into your shoes effective immediately whether incapacitated or not, to make financial choices and decisions. And we typically don't find that it's used unless the person is incapacitated. That's when it typically springs into play for most people. When someone's no longer able to write the check for their mortgage payment or pay their medical expenses, or do basic banking functions, then who they've named as a power of attorney, the attorney in fact goes down to the bank and makes those transactions. So that's the purpose of a durable power of attorney, is to let an individual that's designated take on financial responsibility, keeping in mind that everything that they do with that power of attorney, every transaction that they make, every check that they write, has to be done as though it's in the best interest of the person who made the power effective. So they can't take that money and use it on themselves. They can't legally, they can't take that money and spend it for anything but the care and the best interest of the person who provided the power. So do we find that it gets abused? Occasionally, but there's recourse for that. But again, you got to be careful as to who you name and the powers that they have, and just understand the document. But it is an important planning technique, because without it, oftentimes people find that they don't have the financial ability to care for their parent or loved one because they can't access the money to be able to pay the mortgage or to pay the nursing home or to pay caregivers. And if you don't have it, then again, you find yourself in a guardianship situation. You find yourself going to the probate court and the guardianship court to get orders authorizing you to do exactly what you could have done had you had a power of attorney in place. So again, it's that advanced planning that eliminates all of that potential headache, time, and money of a guardianship situation, just to have someone do what they could have otherwise done with a power of attorney. So yeah, it's an important part of the overall package that we would otherwise provide for people.
Yeah. With great power comes great responsibility.
That's true.
And so kind of another shift that actually the listeners today could be doing on their own right now is reviewing all of their beneficiary clauses. And that would be things like life insurance, annuities, retirement plans, 401ks, IRAs, all of those types of things, because those items, when they have a beneficiary clause, will actually supersede whatever happens with the wills and other things that are out there. It is just moving it directly. And if somebody tells you, oh, well, all your assets are all tied up in a retirement account or life insurance, you're not going through probate. If that's your only asset, that's just flat going out to the beneficiaries, unless you didn't name a beneficiary and it went to the estate, right? And then now you're going through a probate.
Right. No, that is an important piece of the estate planning puzzle, is that, and oftentimes, most people don't fully appreciate or understand the sequence of events and how their assets will be paid out on their death. But you're exactly right. The designation on an account of a beneficiary is the primary means of distribution of that asset. So while an individual may say in their will, I want my assets to go to XYZ, if on their bank account they have designated someone else to be the beneficiary, that gets paid immediately on death to that beneficiary. So that's the primary means of distributing assets on death, if it's designated. Unless an account is held jointly with somebody, if an account's held jointly, then it will pass to the joint account owner. But if not, then it will pass according to the beneficiary designation on the account. And that's how that asset will go. And it's a very simple process. You present a death certificate to the financial institution, you fill out a claim form, and they'll transfer the account and write the check. So sometimes it's a very important part of the planning process, because sometimes people will circumvent their own planning by they want their assets in a will or a trust to go somewhere, but then not check in on the beneficiary designations of their various financial accounts, only to come to realize down the road that those assets passed according to those designations as opposed to what they had thought they would do in a will or a trust. So yeah, the beneficiary designation is the primary means of distributing an asset.
Yeah, I ask the question usually 2 to 3 times, is this all of your retirement accounts? Is this all of your IRAs? Because I sometimes find somebody will have 4, 5, 6 different IRAs or 401ks, and somewhere in the past, we've literally uncovered that somebody that was divorced for 20 years still had their ex-wife listed on an old 401k or a pension or life insurance. And I've seen people turn ghostly white, where it literally, they got sick at their stomach knowing that I just uncovered with a beneficiary review that an ex-spouse was going to get the main assets of an old life insurance that they didn't actually go back and review. So, yeah, that's good stuff. In the world of estate planning, sometimes people think they can outsmart the system with beneficiary clauses or registration clauses. And one of the things, I've had a couple of shocking moments, and you've seen this, I'm sure. I had an elderly woman who had several $100,000 years ago, and she had a son who was in and out of jail, lots of liabilities. He was jointly on her big, large, both checking account and an investment account as joint tenants with rights to survivorship. What kinds of legal things can pop up if you've got somebody that is a liability in action and you're watching this train wreck and they're on accounts with you? What would happen if something blows up with them?
Yeah, it can be a major problem. Again, it's a reason that it is best for everybody to thoroughly review their estate planning, their bank accounts, their designations, because having an account with a joint owner, as I mentioned, that account will transfer to that joint owner, and that joint owner also has access to that account during your life to be able to shift assets or transfer assets. Now that becomes a very difficult legal situation for people to deal with, because if you've named somebody as a joint account owner, then in theory, they have the ability to access that account and use that money. But are they using that money for whose interests? How are they using that money? And who put that money there to begin with? Because what we'll often find is one individual was the sole reason that money is there. And then they've added a name to the account, only to find that individual has withdrawn all of that money and used it for their own benefit. And they were never the source of the income or the asset to begin with. So yeah, the joint account ownership situation can get very difficult, which is why we typically see joint accounts being held by spouses. But beyond that, it becomes a little bit difficult whenever you start putting children on accounts, or other family members on accounts, because then inevitably what you will find is that if you've got 3 children and one of them's on the account, oftentimes 2 of those children won't agree with what's happening on that account and that third child being named on it. And then you've got a situation where you got siblings fighting and what happened with that money and where did it go? And then also, if that one child is on the joint account and the intent of the parent when they die is that the account be split 3 ways, that's not what's going to happen. The legal owner of that account on death of the parent would be the joint account owner, who would then own 100% of that account. Legally, that is that child's money. And it doesn't get split or paid over to the other 2 children. And in most situations, that's probably not what the parent wanted. It's just the reality of legally, this is the sequence and the flow of these monies by virtue of a joint ownership situation. Then you can also run into a situation where even if that child who received that money wanted to split it up and separate it with their siblings, you could have a tax issue if they've received a large sum of money and yet they want to just gift it to the other 2 siblings because they're trying to be fair. Well, there's limitations on gifting. So then you run into some tax ramifications on even wanting to do the right thing. Maybe you're prevented from doing that, or you have to get creative in how you do it. So yeah, how you own the account, who you own it with, how you designate your beneficiaries are critically important in ultimately how your assets will be passed into your heirs.
One of the questions I like to ask when I do see a joint tenants with rights to survivorship, and it's a parent to child, usually an aging parent that potentially could be going into a nursing or assisted living or whatever, and they have this child that's on there. I said, how much do you trust this child? Does your child have a good marriage? Because I've had divorce attorneys that I've talked with that have said, listen, when we do a deposition, we're always finding out, are there joint accounts that you're on? And all of a sudden, mom or grandma might be on the account with this person who's getting divorced. And now it's an asset. It's a grab for the himbo or bimbo that's going out the door. and it wasn't intended that way. And when grandma finds out that something like that is in the works or potentially in the works, it's very upsetting. And so having communication, really important. And so estate planning, and in fact, a lot of the books that I've read have said that a lot of the failure in estate planning is based around communication and trust. And if you communicate and you're trusting each other and you're communicating, the success rate goes up exponentially. A lot of times it's not the technical issues, although technical issues can definitely throw a lot of delays and a lot of frustration. We'll definitely see that one. Would there be some other scenarios that you've seen in regards to parent and child, whether they're minors or adult, that you'd maybe like to share a story or share a reason why getting your estate plan updated would be a really good idea?
Yeah, no, I mean, updating it is very important. If you've done it in the past, you should definitely take a look at it and update it. The frequency that you check it or you update it and make sure everything is in line with your original plan and your current plan, that's up to you. But we always encourage people to do it in major life events. If you've had a divorce or a marriage, a child being born, anything that's significant in your life, a large inheritance. Those are life events that you should always go back and you should check. If I've done it before, here's what I did. Does it still work in this scenario now? Mm-hmm. Because if you don't, what you can find is, it happens a lot, you will have named various individuals to do certain roles in your estate plan 10 years ago, but now maybe those people aren't even living. And now you're left with nobody that you've designated previously. So now that you need them and they come into play, they're not even able to do it. So we see that not infrequently, where people just haven't taken the time to update their documents, and then they're stuck with old documents that don't make sense with their current situation and their current plan. And sadly, we do see a decent amount of abuse in the estate planning situation in terms of family members or non-family members, caregivers, for instance, coming into the mix, and all of a sudden you've had a very nice family relationship with your children for all of these years. And then sadly, you end up with an individual from the outside coming in, befriending an elderly individual, taking advantage of that person and finding out that they have, in fact, made themselves beneficiaries on accounts. They are now the power of attorney because they did some documents that they printed off the internet and got them witnessed and notarized. And so, yes, unfortunately, sadly, I've been party to or part of litigation along those lines over the years that involves families being taken advantage of by third-party individuals who they appear to be good. They appear to be people who are doing well by the family and taking care of an aging parent, only to find out later that while they may have been taking care of them, they were also benefiting their own pocketbooks at the end of the day by getting themselves on documents. So, as family, you just need to make sure that you take care of your parents and your loved ones and check in on them, make sure that they aren't being abused and taken care of financially, make sure that nobody is unduly influencing them to change documents or do things inappropriately, because there is a lot of it that goes on. Sadly, it's very sad.
Yeah. So for the listeners today, I would like to reiterate that, let's say you did some documents years ago and they're sitting in a drawer and you've updated those documents. Please get rid and destroy those old documents and let whoever your main family members are that are going to be a part of your estate, let them know where your documents are, how to find that. Very frustrating. I get a call, mom died, my aunt died. We're going through this stuff. We haven't bound the estate planning stuff yet. I guess it's hidden somewhere. We got a lot of boxes and a lot of stuff to go through, and it's very frustrating. So have that communication with somebody in your family that needs to know where to find these things. It's way too common, and it shouldn't be. It could be avoided.
It can be, to the extent that the family situation warrants it, and hopefully most do. Having that open conversation, that open dialogue with the family, not hiding your documents, not hiding your plan, letting them know in advance, it can eliminate a lot of issues later, where people are just mistakenly, surprised as to find out that what their parents may have wanted to have happen. The documents look different than what they thought. But if you have the conversation, if you if you have that kind of relationship with your children that you can discuss those things with them in advance, then I think it opens that line of communication really opens a lot of doors, and it really helps the process down the road. And it can eliminate a lot of issues just by communicating about those things up front. So yeah. And finding the documents too, all you mentioned, can be a problem. One of the things that we have encountered too in the past is people will mistakenly think that a really good idea is to take your important estate planning documents and lock them into your safe deposit box at the bank. And so with good intention, they go to the bank and they deposit their documents into the safe deposit box, and then they pass away, having named nobody on no other individual.
No other signer on the box.
And so you've got your documents, they're fully prepared, they're effective, they're good to go, but you can't access them because they're in a locked box at the bank that nobody can get into. So then there's an entire legal procedure for getting access to that box. And again, it's a costly, time-consuming process that you just don't want to have to go through as a family who's grieving the loss of a loved one, now trying to figure out how do we get access to a safety deposit box. So safety deposit box has its own place, and it is a good idea for certain things, but putting your documents in it might not be the best place to store them just because there's no ability to access them. At least keep a copy out somewhere, or at least let your family know, here's the attorney that drafted the documents. They will have a copy if you need, post-death to be able to review them. And just so the family knows. Another good thing to do is to have a list of your passwords for electronic, devices, and for all of your various banking accounts, everything that you need to be able to access everything.
Even your cell phone. I mean, how to access the cell phone? What's the password or the code or whatever? So one thing I want to reverse back a little bit. So when I was talking about joint tenants with rights to survivorship with a parent and the child, I've been asked many times, like, well, what could I do to make sure that if I die, that they could pay for the funeral, that there could be some monies that could be available to let's say they only have one child, and they're planning on leaving it to them. Having a payable on death, a POD, payable on death, on that bank account doesn't cost anything. You go in and talk to your teller, get that child put on there after you're gone, after you're dead. Those monies can flow. They get a death certificate and they can have access to monies that now they don't have to wait on court systems and probate or other things that are going on. It's quick and easy to access dollars. On the security side, meaning a brokerage account, it's the transfer on death, TOD. And so instead of having a joint tenants with rights of survivorship on that brokerage account to the adult child, now you're doing that in a TOD format. So it's not giving them access to the money or rights to the money while they're living, you're living. It's only after you're gone. Are there other documents or practical things that could be done in an estate plan that you've seen that have been effective that maybe we haven't covered?
Yeah, I think you made a great point there. And that what we find is that is a very common question, is a very common concern of family members, particularly ones who don't have their own financial resources or means to deal with the loss of a parent. And so they're in a tough situation. They're facing a funeral expense, and they're trying to deal with the loss of a loved one and grieving process, and then trying to come up with a relatively large sum of money to be able to plan a funeral and take care of those final wishes. And it's a great point that you made, and I've advised people of that quite a bit over the years, that take a relatively nominal sum of money, put it in that account, do a POD on it, and that will get that money into the hands of somebody that can take care of those funeral arrangements. Have the discussion with them that this is what I've done, here's how we're going to handle it. Because otherwise you're going to end up with a situation oftentimes where the children or other family members are just going to have to come up with an ability to pay for those expenses. Now, they may likely get reimbursed those expenses once the estate process is underway and they get a personal representative appointed and somebody's there to be able to access the parents' bank accounts to be able to get those funds and reimburse themselves. It just takes some time. Typically we find that those expenses get paid, but it just is not always a convenient way that they get paid to begin with. So it's a common question, but that is one solution.
Yeah, you make a great point there. So I've actually heard, I was at a seminar and this gentleman walks in and he was talking about estate planning. He says, here's what happened. My mom died and I had to walk in, and the funeral cost was $16,000. He said, I had to put it on the credit card. My siblings had no money whatsoever. It put me in a bad situation because I had access to dollars. So I was the one that had to pony that up, and wait months before we could get mom's money. But just that impracticality put a little rub between me and my siblings. And so there's a guy, Ron Blue, and what he told me years ago, he says, a successful estate plan is one where all family members still love each other a year later.
It's a great point.
And that's powerful. I mean, that's his definition of a successful estate plan, is you want everybody to love each other, and you don't want to drive a wedge. You don't want to show favoritism. You don't want to, make it easy on one. And all of a sudden you're going, because I've seen this happen where, one child gets a huge Roth IRA, 100% tax free, and the other one gets an IRA that's fully taxable at 37%, and they're getting a lot less money. They think they're getting the same amount of money, but because of the tax structure and the way that was done, the parent didn't mean to do that, and they weren't given advice. Right. They just saw an asset bucket, but they weren't getting advice. So here's my challenge to you: is that reach out to me. Love to have questions, love to dialogue about what's possible for you. Chad's someone that I highly respect. I can refer you back over to him. Chad would be happy to talk with you about the situation as well. If you've heard something or thought about something that you'd like to email me, scott@stewardshipmatters.net. That's scott@stewardshipmatters.net. Or you could check out some of my other YouTube videos on Rumble or other places on my website. Anyways, thank you for tuning in today. Chad, thank you so much for sharing your wisdom, your experience, your passion for life, and how you're helping and serve other people. I love to do this. I've been doing it for decades, and I'll continue to keep pouring myself into other individuals, and also collaborating with people like Chad. Thank you for meeting today. And any last words you wanted to share, Chad, with the audience?
Yeah, just thank you for the opportunity to come and speak. I mean, again, I'm always available for calls or emails or follow-up questions. Happy to discuss it. It's a complicated process. It's one that a lot of people have not thought about much. And it seems overwhelming. And that I can completely appreciate that. And so to the extent that we can make it simple and explain things in detail in a way that people can understand it, I think that that's the best approach to the estate planning process is to make sure that the person understands it. So to the extent that I can help, great. To the extent that, you find somebody else, fantastic. But I do appreciate the opportunity to come and talk.
Yep.
Dialogue.
Chad, share your number and then repeat your number. Share your telephone number and then repeat it.
Sure. It's 407-637-9324. 407-637-9324. And the email is Chad, CHAD, @Shimel, SHIMEL.law.
Excellent. Thank you so much. Have a great day, folks.